Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 visa, specifically in the context of a recent memorandum issued by United States Citizenship and Immigration Service with respect to so-called requests for evidence. There's another video, it's quite long, that's also on this channel. We go into pretty good depth about the dynamics of how this new memo is probably going to play out. Specifically the policy of the rescission of the no possibility doctrine. For those who are watching this video and don't really understand what I'm talking about in depth, I really do urge you to go check out that other video. I go into rather great detail with respect to this memorandum here issued by USCIS, and I'm not going to go back through all of the sort of minutia of this thing, but suffice it to say, what we're looking at under the new memorandum from USCIS is this. There's effectively not really going to be requests for evidence issued as frequently in cases that are adjudicated by USCIS in the future. I've been thinking about this for a couple of days now before making these videos, and one of the things I think is going to be a strong possibility is I think this will have a rather substantial impact on the processing of fiancé visas. The reason for this is specifically the matter in the past. It was somewhat counterintuitive, and I guess it's still counterintuitive. The K-1's processed faster, and people kind of wondered why. And it was really more just sort of an administrative quirk that they did that. And the reason people thought it was kind of strange is because, at least in a layperson's perspective, perhaps not at a legal level, because there are certain standards that the K-1 actually meets with respect to them being treated much the same way as a marriage visa. People kind of said to themselves in their head, I think, you know, it's a fiancé visa, it's not a marriage visa. I haven't gotten married yet, so maybe that requirement isn't quite met. From a legal standpoint, as long as there's a bona fide intention to marry, K-1s are effectively, from a legal standpoint, treated much the same way as an immigrant spouse visa or a K-3. Moving aside from that, what are we getting at with respect to this video? Well, with this now, the issuance of this no possibility, the rescission of the no possibility doctrine from the prior policy memorandum, we're going to see less RFEs probably issued in the past and more denials where the applicant where the petitioner failed to prove eligibility. And in a K-1 case, one of the issues regarding eligibility are things like the meeting requirement. They're a little bit more intangible than just legal marriage under marriage visa cases. The meeting requirement is a really important one with respect to the K-1. And now that there's no longer going to be RFEs issued, or I'm going to go ahead and assume they're basically just not going to issue RFEs as frequently as they have in the past. There's nothing in the policy memorandum that says that they might not continue issuing RFEs as they always had done. But I don't think they'd issue a policy memorandum if they didn't, have some idea for a major change in mind. So again, with the eligibility requirements, again, the meeting requirement in the K-1, I often have in the past gotten RFEs specifically on that issue. And one could argue that failure to prove that issue up in the initial filing of the petition was basically sufficient to go ahead and say that they are on their face ineligible because they can't prove that they met in person at least once in the 2 years prior to the filing of the underlying K-1 petition. So I think this new policy memorandum is probably going to have a pretty significant impact on the K-1 fiancé visa cases, especially those sort of borderline cases where it's not quite clear to the adjudicator that the couple has in fact met in person in the 2 years prior to the filing of the case. What does this mean as a practical matter to the viewer of this video? Probably not a bad idea to hire a legal professional, candidly. Those who are used to these cases understand how they work, have dealt with the forms, have dealt with the underlying evidence, understand exactly what USCIS adjudicators are looking for and the eligibility requirements in detail. Having that kind of expertise on side when filing these kind of petitions is going to probably be pretty pivotal for cases moving forward, because I don't think it's particularly wise to go ahead and assume, oh, if there's some deficiency, I'll just get an RFE and deal with it. That's probably not going to happen. I think moving forward, we're going to see more denials And I can definitely see circumstances in which K-1s are going to be denied a little bit, maybe a little bit more than marriage visa cases, if for no other reason than you've got the meeting requirement rather than the sort of cut and dried, hard and fast, concrete marriage involved, which is a differentiation between those two kinds of cases, and a differentiation that could result in more denials now that we've seen this policy change from USCIS.